very complex law, and you need to, it's going to take some time for the correct version to prevail, across broad circles. You see, because we've had amendments in the Parliament in 2015, 2016, 2017, all the way up to 2022. And these amendments had to do with the regulations that came to place in the end. Because there were three areas that I think that dominated the conversation, or is it four? There were 4 areas. One was the whole question of the freedom and the right to choose medical services of your choice and not have it dictated to you by any process which could turn up somebody who you don't think is the best doctor or the best medical service. The same thing to do with legal services, where you can't simply go by the price the lawyer is going to charge to get a lawyer to defend the state. Because as you know, litigation in Trinidad and Tobago is furious and fast. Some of them look like small items, but they have serious far-reaching import and consequences for the state and the taxpayer. So every time a man of straw is used by some person to challenge the state on a matter, the state has to put its best defense forward, because to lose the matter for want of quality advocacy is to end up in a very, very difficult situation as the taxpayer, because the state's financial burden is always on the back of the taxpayer. So the state, going forward, has to get competent, experienced advocates at all stages in virtually every event. And that is something that the state will have to be satisfied that in the individual matter, on an ongoing basis, on a case-by-case basis, that you are having the required competence and the advocate of your choice. So that caused us to have made an amendment to give the state the right and the freedom to do that. And the third one was government-to-government arrangements. One such example was our use of the Australian government to obtain those ferries that we did and the Coast Guard vessels. That is not a matter for a public servant. That has to be a decision of the administrative directorate of the country to do that. And we believe, I don't expect everybody to agree, but we believe that such an intervention by the government or any government is required if the government is to play its role as the premier decision maker on behalf of the wider citizenry. The government must be able to have freedom to deal with other sovereigns on matters which the government determines requires the government's intervention. And of course, the whole question of borrowing, the Ministry of Finance will have to determine how borrowings are done in dealing with the public and other debt. This is a matter for the Ministry of Finance. And of course, while there are guidelines and strict regulations, the freedom to get the best deal for the country in financing is something that. So those are the 4 areas that the amendments were made. And I've seen in response to that, persons who I suspect have not even read the law and paid no attention to the parliamentary debates speak about the bill being gutted. In fact, one of the amendments we made was when the regulator himself pointed out the existing law had required that the regulator dispose of property. And he had to point out to us, and it was amended, that you can't be regulator and disposer at the same time. You're either fish or fowl. And we had to make an amendment where the actual disposing of state property is not being done by the regulator. And that was one suggestion that came from the regulator. And of course, we were pilloried for interfering with the law as first passed. So the law did have some requirements to be shaped to where it is today. And I think we're in a much better place, although it is not, for me, and I'm speaking here as a parliamentarian and as Prime Minister, and we are not at the most comfortable place. We now have to move with some evolution and understanding of this law to get the best out of it.